Hello and welcome. Today we're going to talk about something incredibly powerful, a legal tool that can literally stop family property fights before they even begin. It's a way to formally choose peace over a painful, drawn-out court battle. It's called a family arrangement. So let me ask you this. When you think about your family's inheritance, what comes to mind? Is it a blessing, a source of security, or does it feel more like a potential battleground? It's a fear that so many families have, that property and money could tear them apart. But what if I told you there's a legal framework designed specifically to defuse that ticking time bomb?
Well, that solution is the family arrangement. And I want you to stop thinking of it as some stuffy, complicated legal document. Instead, think of it as a formal peace treaty for your family. It's designed to protect your assets, yes, but way more importantly, it's designed to protect your relationships.
So, what is it exactly? Well, at its very core, a family arrangement is just an agreement between family members to sort out their property issues without fighting. The whole point isn't just to slice up the pie, it's about preserving the family's peace, its security, and its honor, all while keeping everyone out of a messy, expensive, and emotionally draining court process. And listen, this isn't some shady legal loophole. Get this. The Supreme Court of India itself is a huge fan of these arrangements. Why? Because the entire legal system would much rather see families find harmony on their own than see them tear each other apart in court. They know that family peace is priceless.
Okay, so you're probably thinking, this sounds great, but how do we make one of these peace treaties that will actually hold up in court? Well, there are a few fundamental ground rules, the essentials that you have to follow to make sure your agreement is absolutely rock solid.
And here's what's so fascinating. The core rules are actually pretty straightforward. There are basically 4 golden rules. First, it has to be genuine. You have to be trying to solve a real or at least a potential family squabble. Second, it has to be voluntary. No one can be forced or tricked into it. Third, everyone involved needs to have some kind of pre-existing claim to the property. And fourth, and this is the one that surprises almost everyone, it can be oral. That's right. It doesn't always have to be a big, formal written document.
Now, let's zoom in on that third point, the pre-existing claim, because this is super important. This doesn't mean you need to have your name on a deed already. It could be a future right to inherit, a claim you think you have, or even just a fuzzy, disputed interest. The whole magic of the family arrangement is that it takes all these different potential claims and settles them, once and for all.
All right, so this brings us to the big one, the question that everybody asks. Is a handshake enough, or do we need a formal, stamped, registered deed? Well, the answer hinges on one really crucial distinction. And this slide lays it out perfectly. On the left, you have the deal that's made verbally. The agreement happens first, through conversation. Later, you might jot down a memo just to have a record of what you all agreed to. That memo, that record, usually doesn't need to be registered. But on the right, you have a situation where the written document is the deal. It's the thing that creates the new property rights. In that case, it's a formal deed, and that almost always has to be registered. The timing and the purpose of the document are everything.
So let's walk through how this actually plays out in the real world. First, there's some kind of dispute, or maybe you just see one on the horizon. Then, the family gets together to negotiate. Once everyone voluntarily reaches an agreement, they immediately act on it. Maybe someone moves into a house or takes possession of a piece of land. And only after all of that is done, you might create that optional written record, just to have the terms down on paper.
Okay, we've covered the basics of how it works, but now we have to talk about the fine print. This is the stuff you absolutely need to know, the impact on your taxes and the hidden traps that can make the whole agreement completely fall apart. And let's start with some really good news, especially when it comes to taxes. A genuine family arrangement isn't considered a transfer of property in the eyes of the law. Think of it more like a realignment of rights that people already had a claim to. And because it's not a transfer, in many cases, that means no capital gains tax. That's a huge deal. But, and this is a big but, it only works if the arrangement is totally legitimate.
And that brings us to the traps, the ways these peace treaties can fail. An arrangement can be thrown out if there was any kind of fraud or coercion involved. It can fail if there wasn't even a real dispute to begin with. You can't just invent one. It's also void if the main goal was illegal, like trying to cheat creditors or, crucially, to dodge taxes. And of course, if you make a formal written deed but then forget to register it, that can make it unenforceable too.
So really, it all boils down to this. Authenticity is everything. The law is on your side when you use a family arrangement as a genuine tool for peace. But if you try to use it as a clever disguise for something else, like a secret sale or just a scheme to avoid taxes, trust me, the courts and the taxman will see right through it.
In the end, this is about so much more than just who gets what. A family arrangement is a conscious decision about your family's future. It's a choice to protect relationships and secure a peaceful legacy. So the question you have to ask yourself is, what future are you building for your family, and is it protected?